Tonight, the Robert Durst saga, it continues. That is the millionaire real estate heir switched to a Louisiana prison with a mental health unit that as police search his Houston home. But there's still a whole lot of questions about the case, and our legal panel will sound off. Then, after racist chants were caught on tape, an entire chapter of an Oklahoma fraternity shut down. Where do we draw the line between, albeit ugly speech, but free speech, and hate speech? And singer and actress Ashley Judd got trolled on Twitter. Nothing new there, but now she wants to sue the culprits. We ask you if she's got a case. Good evening and welcome to RFL. I'm Richard French. Thank you so much for joining us. And we're going to start with a case that everybody is talking about this week, the apparent televised confession of Robert Durst and the tape heard around the world.
What the hell did I do? Kill them all. Of course.
Now that voice you heard was Durst in the HBO show Jinx. He was caught on a hot mic. That's what we call in the business with the microphones on. The person doesn't realize, even if they've left the set, that the microphone is still recording. He took a bathroom break here and he made comments that could actually put him in even hotter water. Now, for the sake of this conversation, and just for the sake of it, let's assume that that tape was not altered, as some suggest and others say was in fact what it was. But the question remains, is what he said on a hot microphone, not to the police, but in the recording of a show, and even in a restroom at that, admissible in a court of law? Here for analysis on this and other subjects this hour is our RFL legal panel. Jim Kasouris, a criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the Bar Association in both Queens and New York City, and is a visiting professor at the University of Birmingham in England. To his left is Doug Van Nuys. Doug is a founding partner of Carson Van Nuys, focusing on, if I can say this in English, corporate misconduct, and selected by the Legal 500 as one of the most influential trial lawyers in the nation. And Mayo Bartlett. He is an attorney at the law offices of Mayo Bartlett PLLC and a former chief of the Bias Crimes Unit at the Westchester County District Attorney's Office. Gentlemen, all, thank you for the time. And our first question, big question, is about that Durst confession, if we want to call it, and its admissibility. And I want to hear, as we do here, we have one debate. We're going to a whole host of stuff with the 6 minutes, but we have one debate, and we have opening arguments. And the first one is arguing that the tape should not be admissible, and that comes from Jim Kasouris. Go, Jim.
It's my position that tape is inadmissible. There's no question that an individual has a clear expectation, a right to privacy when he excuses himself and goes into a bathroom. That's initially. Now, some will claim that these statements are admissible because they were made to reporters, filmmakers, and not the state, and that the Constitution protects you only from state intrusion. Well, this may be so, but I would submit that under the circumstances we have here, HBO was actually an agent of the Los Angeles Police Department and the prosecution. Let's look at this. The timing of this arrest, based entirely on the investigation conducted not by law enforcement, who's been investigating him to no avail for decades, but by filmmakers who were clearly working with the police. It has been reported, for instance, that HBO agreed to turn over all the material they taped to authorities before airing it. Why? Obviously, in order to gain the advantage of the materials before Mr. Durst could realize that he may have incriminated himself and fled. I submit that this is not a simple case of a civilian tape recording another person. This was a powerful company doing the job of law enforcement for law enforcement under the guise of a documentary. At a minimum, the defense is entitled to all discovery related to the agreements between HBO and law enforcement, and an evidentiary hearing must be ordered to determine whether, in fact, someone in law enforcement went to HBO and said, hey, look, trip this guy up for us.
And he does it as the beat goes on.
Finally got that.
There we go. And now, to tell us why the Durst confession ought to be allowed in court, argues Doug Van Nuys.
Okay, Mr. Durst will probably argue that he had an expectation of privacy when he entered the bathroom. The whole theory of the Constitution is that you have an expectation of privacy under certain circumstances when you're dealing with the police. But here, he was dealing with filmmakers. Also, you can't have an expectation of privacy when you're wearing a microphone. The fact that you forgot to turn the microphone off is simply not a good reason to have a statement excluded. Mr. Durst was being recorded by a civilian. If a civilian is tape recording you, the statement is admissible in court if it's relevant to the crime committed. Mr. Durst will claim that his statement should be excluded because it's hearsay, but hearsay rules do not apply when the declarant is in the action which the party is either as an individual or a representative capacity. Mr. Durst will probably claim that his recorded statement should be excluded because it's meaningless. Whether what Mr. Durst said was meaningless is an issue that a jury is uniquely qualified to answer. The statement should be admitted into evidence.
All right. May, you've heard from the two of them. This is where you get to have the fun thing. You get to sit across and grill them like a judge does. Have at it.
Mr. Kasouris, are you suggesting that Mr. Durst had no idea that he was being recorded?
Well, we don't know that, and we need to find out. For example, everybody keeps saying you have no expectation of privacy when you have a microphone on and you should have turned it off. Maybe he thought that when he was not actually being interviewed for the documentary, that it would be turned off automatically, that he was able to actually go to the bathroom, undress himself, relieve himself, without surrendering his right to privacy. So I don't know what was in his head, and I think that that's what's most important.
How is it that you assert that HBO is an agent of the police, though?
Well, yeah, I want to hear this one, too.
Well, very simply, very simply. We know that they agreed to turn everything over before they aired it, number one. We know that for months and months and months they were in contact with the LAPD. We know that the LAPD for 2 decades has been trying to nail them and has been unsuccessful. And so you have HBO saying, we got them for 6 hours. I'm not saying 100% that's what happened, but I think we can all agree that an evidentiary hearing is required. I want to know what agreements were made between them, and the conversations that were had between them. And I think that it's very likely that there was at least some kind of an agreement between them for that.
But Jim, if they were acting as an agent, why did they sit on this tape for as long as they did? If they're really acting as basically in concert with the LAPD, why wouldn't they turn it over as soon as they caught it on the mic?
They did. Rich,
it took a while before they turned it over.
My understanding is that the LAPD has had this tape for months. So, you know, months and months. This is not something where HBO... Here's the answer. If HBO first aired it so that they could get the sensationalism of it and then turned it over, well, then they're thinking only of themselves and their ratings. They turned this over months before, and LAPD did nothing with it. Now, why? I don't know. But my understanding is they didn't sit on it. You may know better.
Well, Mr. Varnois, what about your suggestion that because he had a microphone on, just a mere having a microphone on your person means you have no expectation of privacy? Suppose you had a cell phone with you. Do you have an expectation of privacy with your cell phone? Suppose that phone is recording your conversation.
Well, I think the difference is you expect a microphone to take your voice and send it out to the public. You don't expect a cell phone that's off to be recording you. There's a difference between the devices.
But do you agree that there's an expectation that when you go into the bathroom, you're not still being recorded?
Well, I think that there probably is an expectation that you have personally, whether there's a legal expectation of privacy. I don't think so. I think if you walk into a bathroom and you mutter to yourself and there's somebody in a stall in the bathroom and they hear you, they hear you.
Would it matter if that state is a one-party or two-party consent state?
Well, I guess the law of the individual state does matter. But
all right, so you've heard the pros and the cons here. When we come back, we're going to get into a whole lot of additional questions I have relating to the Durst case. Like, for example, something happens 10 years, 20 years, 30 years old. How hard is it to actually prosecute these cold cases? Everybody at the table has been now both a defense attorney and before that worked as a prosecutor as well. We'll get into that. Plus, we'll get the verdict here as the folks in the control room will serve as our jury here. We'll tell you who made the more convincing argument, whether or not that tape should be admissible or not. Stay with us.